Hey everyone, we're going to be talking about judicial notice. This isn't something that you would ever object to, but it's a process of eliciting evidence and testimony into the record. Usually, though, it's not for evidence and testimony, but rather for priorly adjudicated facts. We're going to talk a little bit more about it, what it means, how to use it, and a couple examples. I can give a couple examples from past years and maybe even apply to this case. So let's just take a look and read Rule 201. The rule governs judicial notice of an adjudicated fact only, not a legislative fact. What this means is that you cannot take judicial notice of statutes. At least technically you can't. You can't make the jury known or to the judge known like what a statute says on a particular issue. What this is for, when we're talking about adjudicated facts, that term, it means things like the order on motions in limine. Those motions in limine have been priorly ruled on by Judge Butler. That's what adjudicated means, that they have been priorly decided by a judge in trial. So the motions in limine are priorly adjudicated. The same way, stipulations are thought to be priorly adjudicated because both sides have come to a legal agreement that this is how the facts are. So you can take judicial notice of stipulations. What you can also take judicial notice of, and most applicably, I think, probably the best way to do this, maybe not the most common, but the best way to use judicial notice is to make reference to a case law. So case laws are all priorly adjudicated facts. Once a case has come down on, a certain interpretation of a statute, then that is an adjudicated fact, not a legislative one under Rule 201A. The way you would make So the process here, and I should probably explain, is usually happens during pretrial. Your Honor, permission to approach with all of these documents that have to do with the case. If you want to bring the judge's attention to a specific motion in limine, if you want to bring the judge's attention to a specific stipulation, you can say, Your Honor, you can turn to the first page of those stipulations. Stipulation 3, at this time we take judicial notice that this trial has been bifurcated and that damages will be decided at a different point in time. You can take judicial notice of that. That's one of the stipulations. The big one in this case, when you would do something like that, is before closing arguments, taking judicial notice of motion in limine number 4. If Jesse has chosen not to testify. If by the end of the defense's case in chief, Jesse hasn't testified, you can bring up this 4th motion in limine, which includes within it an instruction the judge must give to the jury about the presuming guilt or innocence on Jesse's behalf when not testifying. That's when this is going to come up, and you would use judicial notice. So I would phrase it as, Your Honor, now that the defense has rested their case in chief and Jesse Duran, the alleged shooter, has not testified, we would like to take judicial notice of motion in limine number 4, which talks about this exact situation when Jesse Duran chooses not to testify. They'll go, they'll read it, they'll understand, and they'll issue their instruction before closing arguments. The kinds of facts that may be judicially noticed, 201B. The court may judicially notice a fact that is not subject to reasonable dispute because it is generally known within the trial court's territorial jurisdiction. So like binding case law falls under that type of evidence. Or 2, can be accurately or readily determined from sources whose accuracy cannot be reasonably questioned. Stipulations is essentially what that means. The fact that Sidney Park is dead can be very rapidly determined from sources whose accuracy cannot be reasonably questioned because everyone agrees to it, 1, and 2, because there's a valid autopsy report. So that's the kinds of facts that can be judicially taken notice of. Stipulations, motions in limine under 201B1, and stipulations under 201B2. The court must take judicial notice if a party requests it and the court is supplied with that necessary information. So because at pretrial, all the documents are presented to the judge, if the judge has confirmation that those documents are accurate, which they would in mock trial, they must take judicial notice if a side requests it and it doesn't bar any of the other permissible rules in 201. It can happen at any time, 201D. And the other side, or the other attorney, can comment on particular interpretations that might be included within a taking of judicial notice. So like I take judicial notice of a case law and make an argument briefly as to what I believe the case law held. If I kind of misconstrue the evidence, the other side has an opportunity to try and correct me or like compromise on like what the notice is actually doing in this instance. Not every time that you take judicial notice of something is the jury instructed of that same fact. It's just important to note. In mock trial, it kind of works that way because your judges almost always are your jury, but it's important to keep in mind. Going back to when you would want to be heard when taking judicial notice, there was a case law about agency theory 3 years ago in the Neptune case. Agency theory means that employees of a company, what they know can be attributed to the company. That was a case law called Veer v. Londo. And I would take judicial notice that I would take a judicial notice of the case law, of the ruling, and state my interpretation. Namely, the interpretation that I just gave, that this case law says that all employees and their knowledge can be attributed to the company when it comes to liability purposes in a civil case. If someone else had a different, and oftentimes they did have a different interpretation of that case law, they have an opportunity to be heard before we just move on from the taking of that judicial notice. That's all that 201E is allowing you to do. That's judicial notice. It's a very powerful tool. It can show an advanced level of the law and understanding of proper procedure if you do it properly. So keep it in mind. Maybe it's something to implement when it comes to pretrial, and know that it's a legal thing that people can do if it's done against you. Hope that helped.